advice in reference to the Baronetcy of Pringle of Stichill?
Lord Hodge will explain the advice the Board is tendering to Her Majesty.
This is a reference from Her Majesty under Section 4 of the Judicial Committee Act 1833. It concerns the question as to who is entitled to be enrolled in the official roll of the baronetage as the Baronet of Pringle of Stichill after the death of the 10th Baronet, Sir Steuart Pringle, in April 2013. It also raises a question of general importance about the use of DNA evidence to challenge an apparent heir's entitlement to succeed to a title or to property by its exposure to irregular occurrences in previous generations of the family. In 1683, King Charles II granted the Baronetcy of Pringle of Stichill to Robert Pringle of Stichill and the male heirs of his body. As a result, the person entitled to the baronetcy hundreds of years later is the person who is the nearest male descendant of the first baronet. In this case, it was accepted by all parties that the 8th baronet, who lived from 1871 until 1919, had been the male heir of the first baronet and thus correctly enrolled as Baronet Pringle of Stichill. His wife, Florence Vaughan, gave birth to a son, Norman Hamilton Pringle, who became the 9th Baronet on his death, and also to 2 more sons. When Norman Hamilton Pringle died in 1961, his eldest son, Sir Steuart Pringle, became the 10th Baronet. Both the 9th Baronet and later the 10th Baronet were enrolled in the official roll of the baronetage without opposition. The claimants to succeed to the baronetcy are now Sir Steuart's eldest son, Simon Pringle, whom I will call Simon, and Norman Murray Pringle, whom I will call Murray. Murray is the eldest son of the second son of the 8th Baronet. He claims that he is entitled to succeed to the baronetcy on the ground that Norman Hamilton Pringle, although born during the marriage of the 8th Baronet and his wife, was not in fact the son of the 8th Baronet, but was the product of an encounter between Florence Vaughan and another man. Thus Murray asserts that his own father, Ronald Steuart Pringle, who was apparently the second son of the 8th Baronet, was in fact the eldest son. As such, he asserts that his father had been the male heir of the first baronet, and that, since his father's death in 1968, he, Murray, has been entitled to be enrolled as the Baronet of Pringle of Stichill by right of blood. Murray founded a project called the Pringle Surname Project in order to determine the chieftainship of the clan Pringle. He persuaded the 10th Baronet, Sir Steuart Pringle, to give a sample of his DNA for the purposes of that project. On receiving the results of the DNA analysis, Murray asserted that he was entitled to be the Baronet of Stichill. Experts have given their opinion that the analysis of the DNA of Sir Steuart Pringle and other members of the Pringle family has given, and I quote, very strong support, unquote, for Murray's claim, because it suggests that the 8th Baronet was Murray's grandfather, but not the grandfather of Sir Steuart Pringle, the 10th Baronet. Simon, having been raised to expect that he would become the 11th Baronet, unsurprisingly challenges Murray's claim. He does not dispute the DNA evidence, but seeks its exclusion on the grounds of public policy. Her Majesty has referred the matter to the Board to advise firstly as to who is entitled to be entered on the official roll as the Baronet of Pringle of Stichill, and secondly, whether DNA evidence can be admitted in order to determine that question. In this judgment, the Board advises Her Majesty that it can find no ground for excluding the DNA evidence, which demonstrates to a high degree of probability that Norman Hamilton Pringle was not the son of the 8th Baronet. Accordingly, it is Murray and not Simon who is the male heir of the first Baronet and so entitled to succeed to the baronetcy. In this judgment, the board discusses both English law and Scots law, but proceeds on the basis that Scots law governs questions as to the entitlement to succeed to the baronetcy. There has long been a presumption in Scots law, and also in English law, that where a child is born during the marriage of a couple, the husband is the father of the child. Before the development of scientific evidence, first in the form of blood tests, and more recently and comprehensively in DNA, it was very difficult to rebut that presumption, particularly after the passage of time. But then, as now, paternity is a question of fact, and since 1986 in Scots law, the presumption may be rebutted on the balance of probabilities. DNA evidence, if admissible, can be used to establish paternity to a high degree of probability. It is widely accepted as a means of ascertaining a person's identity in both civil and criminal matters. It can readily rebut evidential presumptions. The board found no ground of public policy for the exclusion of DNA evidence. In relation to Simon's other defences, the board held first that Murray's claim had not been extinguished by the passage of time because, under Scots law, the claim to succeed by right of blood was, in Scottish terminology, imprescriptible. That is, the passage of time cannot exclude that right. Secondly, Murray was not barred by delay from asserting his right because he learned of Norman Hamilton Pringle's illegitimacy only on receiving the DNA results. Thirdly, he did not breach an obligation of confidentiality to Sir Steuart Pringle in using the DNA results to assert his claim. And fourthly, even if Murray's use of the DNA had amounted to a breach of duty under the Data Protection Act 1998, it would have been a disproportionate response to exclude such powerful evidence from consideration. The board therefore humbly advises Her Majesty that Murray is entitled to be enrolled as the Baronet Pringle of Stichill.
The court is now adjourned.